Good morning and welcome to the Kansas Supreme Court this morning. We welcome both those who are in the courtroom as well as those who are watching on our live stream. We only have one case on the morning docket, and I will call that case at this time. It is 124-378, League of Women Voters of Kansas, Loud Light, Kansas Appleseed Center of Law and Justice, Inc., and Topeka Independent Living Resource Center appellants versus Scott Schwab in his official capacity as Kansas Secretary of State and Kris Kobach in his official capacity as Kansas Attorney General as appellees. Will counsel please come to the lectern and enter their appearances?
Good morning. May it please support. We represent the appellants. My name is Pedro Irigaray. We represent League of Women Voters of Kansas, Loud Light, Kansas Appleseed Center for Law and Justice, Inc., and Topeka Independent Living Resource Center. We're present and ready for argument.
Good morning. May it please the court, Elizabeth Frost, also representing the appellants. Madam Chief Justice, I would like to request 3 minutes for rebuttal.
3 minutes is granted.
Thank you.
Thank you, counsel.
Morning, Chief Justice Brad Schlossman for the defendants, appellees, and with me at council table is Tony Powell, the Solicitor General, ready and present for argument.
Thank you, Mr. Charlton. Before we begin, I'd like to just take a moment to explain to those who may not be familiar with the processes that we use or have seen us in oral argument before, that we have received briefs from the parties. We have also had the record that was developed in the Court of Appeals, so transcripts, the motions, the orders of the district court, and other documents that are available to us. The court is familiar with those. We have also done our own legal research to some extent. May still have more to go, but we hopefully have done quite a bit of legal research on the issues that are before us. So we have made notes, of course, to remind us about the contents of all of those documents and about the details of the parties' arguments. So you may at times see us looking at the notebooks, the papers, the computers that are sitting before us. We just want to assure you that when we do that, we are doing it only to refresh our memory or to look exactly at the language that might be involved in a statute, a case, or something else. We are certainly not distracted, and we are still actively listening to the arguments of counsel whenever we are doing that. With that explanation, I would ask Ms. Frost to please come to the.
Good morning. May it please the court. My name is Elizabeth Frost. I'm here on behalf of the appellants today. And I'll just jump right in. The plain text of the challenge provisions is almost uniquely unconstitutional. Every direction you look, you find a constitutional infirmity. The district court avoided this inevitable result by reading in language into the statute that wasn't there, ignoring language that was, and misapplying the legal tests. It denied the temporary injunction on this basis, and the state defended it by rewriting the statute as well. In fact, the other TI factors were barely contested at all. When the district court's errors are corrected, the only conclusion is that the laws are unconstitutional, either because they're vague, overbroad, or impermissible content-based restrictions, or all of the above.
Do you have one that's stronger than the others, or what do you, if you could prioritize, how would you approach it in terms of vagueness, overbroad, and facially?
Sure, Justice Rosen. So I've actually considered this quite a bit, as you can imagine. And, they are, I think, uniquely infirm. I think that in a lot of ways, vagueness is maybe the clearest path under this court's precedent. If you look at the State v. Harris, that of course laid out the test for vagueness and emphasized that although often when we talk about vagueness, we talk about the notice given to the parties, that actually the second piece of vagueness, the risk of arbitrary enforcement may be even more problematic because it, of course, moves away from the legislature, the decision of what is criminalized, and instead gives that to the courts and to law enforcement. And this case, in a lot of ways, is like Harris in the sense of the record. We don't have to guess as to whether different government officials might read the law differently. We know they do. I think the risk of arbitrary enforcement is so high. On the notice piece, that alone, frankly, is enough to invalidate the statute. But on the notice piece, the statute also has some afflictions like the stalking statute at issue in Bryan, where it both lacks a subjective intent requirement. And this is one of the things, of course, the district court did, which was replace an explicit knowing intent requirement with a subjective intent requirement. And it lacks a reasonable observer requirement as well. For the triggers 2 and 3 are both really about how the speech appears to other people. In fact, the last time we were here, the state's attorney acknowledged that you need a reasonable person to save the statute. So each of these things are independently reasons alone to find vagueness. Now, the problem, of course, is vagueness and overbreadth, as Harris talks about, often overlap. I mean, a law can be so vague on its face that it's effectively overbroad because it reaches constitutionally protected conduct. Or as this court applied the overbreadth test in Trotter, it basically asked, can it be read to reach constitutionally protected conduct? And although, of course, the decision that this court entered on standing was not on the merits, it did emphasize repeatedly the lack of clarity in the plain text. And that same lack of clarity, I think, ultimately dooms the statute under the overbreadth doctrine and probably the vagueness doctrine as well.
What would a reasonable listener standard do to your argument?
Well, a reasonable listener
Happen to adopt it. What?
It would solve one problem in a statute that I think is just, I mean, is sort of rotten to its core in many different areas. I think I mentioned just last time we were here, I think someone asked me, would a reasonable listener standard save the statute? And the answer is no. It might save a different statute, but that's just sort of another piece of it. Because you still don't have the subjective intent standard that you require. It's still, to boil it down as simple as possible, every time I think about this, we always come back to the same place, which is that it is still not clear what A2 and A3 actually do. That is not covered by A1 or is not covered by other statutes that already exist in the law. And this court noted in the standing decision that it is facially a content-based restriction. So then the question just becomes, is it a permissible content-based restriction? And of course, content-based restrictions are generally not permissible, except in the very narrow areas where they are addressing speech that is entirely outside the First Amendment's protections. But that's not A2 and A3. One of the things that I've been thinking about a lot that I think is really interesting is the same time this law was passed, there was another law that was passed by the Kansas legislature, and it became an issue of a federal court lawsuit, Vote America v. Schwab. And there were two parts of it, but one part in particular specifically criminalized, made it a misdemeanor, not a felony like this law, but specifically criminalized the sending of absentee ballot applications to voters that had any information filled in on them. And the argument that the state made in that case for the necessity of that specific law was that voters were getting multiple mailings. with things that, were official voter registration or absentee ballot registration forms. And they were confused. Where are they coming from? Am I submitting several of them? It was causing some administrative difficulties. The federal district court had no problem finding that that was protected First Amendment conduct and enjoining the law. And in fact, the same defendants, in this case, the Attorney General and the Secretary of State, ultimately acquiesced to that, entering in a consent judgment. Now we're hearing, some argument that, well, that's what this law is supposed to do. This law is supposed to protect Kansas voters from getting mailings that they're confused about or, not knowing whether or not they've already registered. But they can't criminalize through a vague law that doesn't say the explicit, what a federal district court found explicitly violated the First Amendment. And of course, well, this is under the Kansas Constitution. At the very least, the Kansas Constitution goes as far as the federal Constitution.
I want to make sure I understand your all's activities collectively, the plaintiffs. Is there any risk to your activities if you can avoid criminal prosecution by having a disclaimer on your literature or a button on your lapel that just says, I ain't an election official?
So there is binding Supreme Court precedent that says that that would violate the First Amendment. Meyer and Buckley, which both involved petition regulators, one of the things involved in the Colorado, it was a series of laws that actually the people passed through initiative to regulate the initiative process, was simply requiring petition gatherers to wear name tags. And what the Supreme Court said was, unless you have a specific showing that you need this to really prevent some real ill, you can't require them to wear name tags. And the reason is because it narrows the pool of available circulators. It narrows the pool of people who carry the message because they are afraid of the crime. They're afraid that maybe they'll screw up the message. Maybe they'll forget their name tag, and they're less willing to do it. So I think both of those cases would probably not allow for that.
I was thinking about, as a sideline on that inquiry, the references that the Douglas County election official said that they give out to nonprofit groups a bunch of literature. I'm trying to figure out, certainly the First Amendment ought to protect anybody to stand out on a street corner and hand out official government literature without making it a felony. Even if someone were to look at it and go, ooh, maybe this person works for the office. I mean, and I assume that would be your view.
Oh, I think absolutely that's right. And I was responding to, maybe I misheard the question, but the idea that they might have to, that they might be able to avoid it by offering some additional language. The other.
That was my question.
Okay.
Now it's now chasing a different.
Yeah, yes, I agree with that. Well, if the court has no further questions, maybe I'll save the rest of my time for rebuttal.
Well, let me ask, with Counterman, the U.S. Supreme Court decision in Counterman suggested that even when you're trying to regulate a historically unprotected category of speech to protect, the chilling effect of that regulation, you have to have that subjective mens rea requirement. But what factors do we look to in deciding what level of mens rea is appropriate? Because this one has a knowing. So I'm assuming your argument is it has to be intentional, but what sort of factors has the U.S. Supreme Court or other courts identified to sort of guide our discretion in sort of assessing the appropriate mens rea?
Yeah, so I think there's two, and I think they're articulated in Counterman. I think that Counterman sort of creates this, I guess, timeline, if you will, and the closer you get to core protected speech, the higher the level of mens rea has to be. And I think you see that reflected in actually this court's decisions in the stalking case in Bryan, even though Stalking is obviously not protected political speech. The danger that unless you have very specific guardrails to make sure you're not actually picking up someone who's sort of just going about their business and has, created a feeling in someone else that either both isn't intentional, but actually Brian says it's not just enough that it's not intentional. The person has to actually intend to cause harm. And I think that does reflect what you see in Counterman, which is this idea that when you are in a space where there is some risk that you could pick up protected speech, even if it's not core political protected speech, which is what we're talking about here, you really need to dial up the intent requirement. And you probably need some other safeguards. I think Brian laid out 4, one of which was also said that you needed explicitly to say you weren't covering unconstitutional or constitutionally protected conduct. You needed an objective listener standard, right? You needed all of those things. So I think that's reflected in this court's jurisprudence as well.
What do we do with the posture of the case this portion of the case that's before us now is on the temporary injunction, and say you're likely to prevail in the declaratory judgment action? What do we do with the other 4 factors that are out there? The district court never dealt with them. The Court of Appeals never dealt with them. They're briefed slightly by both parties. What should we do with this, given our court and what we typically do with these kinds of situations?
Yes, well, it's a constitutional harm. So to some degree, the rest of the factors tend to fall in line with that. The irreparable harm, I'll say today is actually the last day for voter registration for the presidential primary, which means that we filed this motion for a temporary injunction in July of 2021. This is the 7th election that the plaintiffs have not been able to freely register voters without fear that they will be arrested or prosecuted for, that really important civic duty. I think the reason the state had an opportunity to brief it. I think the reason the state didn't really contest those other 3 factors and instead really relied on this rewriting of the statute is because the irreparable harm becomes very obvious at that point. The public interest surely enables this. I think the only argument the state made on the other factors was that it would hurt them to not be able to enforce the law. But of course, there's no right for a state to enforce an unconstitutional law. So, I think given under this court's rules, it can reverse. 8.03J4, right? This court can remand to the district court for reconsideration of issues in light of the authority identified in the order, or may dispose of the issues as it deems appropriate. So I think this court could absolutely enter an injunction if it wanted to, or could remand to the district court and say, these laws are unconstitutional on their face. They're very likely to succeed on the merits. The rest falls, and please enter a temporary injunction as quickly as possible. Every single day that goes by that the plaintiffs are under this threat is a harm not just to them, but to the public. Thank you very much.
Chief Justice Lukert, and may it please the court. This lawsuit has addressed a number of statutory issues in this case, but at the end of the day, if the court applies traditional rules of statutory construction and the normal canons that must apply here, this statute can be applied in a constitutional manner. The plaintiffs here are aggressively seeking to avoid the court applying those traditional canons in order to take the most unkind, uncharitable, and aggressive interpretation they can. But that interpretation, that approach, if you read the Counterman opinion, that is exactly the opposite of what a court must do. There is a subjective component in this statute. It is the word knowingly. It applies to every single element, and the approach in the statute is focused on the speaker. I know that the plaintiffs have tried to say that it's all focused on the subjective views of a third-party listener. And that's how they want to read the statute, because that would then aid them in invalidating it entirely. But if the court interprets it in a manner that focuses on the speaker, that says that requires the speaker knowingly have that mens rea, and even if the statute theoretically could be read in the way that the plaintiffs want to read it, cases like Alanis, cases that we've cited in our brief, including from this court in interest of MML and State v. Clark, the Hansen case from 2023, the Ruan case from the U.S. Supreme Court in 2022, all of those cases say that a court, in evaluating a First Amendment challenge, a free speech challenge here in this case under the Kansas Constitution, has a duty to, if necessary, insert words in order to ensure that the plaintiff, that the speaker, the defendant in these kind of cases, have the requisite degree of criminal culpability in order to ensure that the only thing prohibited is non-protected conduct. And in this case, what's happened is that the focus on the statute is trying to address trying to prohibit individuals from confusing voters. That is the kind of conduct that the Supreme Court has held is important to regulate. They held that in the Burson v. Freeman case.
Counsel, I'll
Yes.
stop you there and just,
Sure.
the question in the back of my mind is, it strikes me that that the argument you're making stumbles over what is really a fact question, which is the record provided by the plaintiffs below made factual allegations with respect to this very thing, the word knowingly. And the allegation was, we know that I think this court characterized as unreasonable listeners out there who will unreasonably misunderstand our speech. And this court accepted those allegations as true for the purposes of the standing portion of the case. And I don't think the state challenged that. But well, I guess the question is, does that tie our hands? Like, how can we reach your legal argument when we are stuck with that factual claim?
I would say that if you interpret the statute as a legal matter, what they're alleging is that they know that people are confused. But at the same time, in their allegations, it's also uncontested that they never knowingly misrepresent themselves as election officials. So essentially what they're saying, and when people ask, they tell those individuals, they disabuse them of any notion that they are in fact election
But
officials.
the knowing mens rea does not modify representing self as election official. It modifies giving the appearance of being an election official. And that, as I understand, at least that's the core of the plaintiff's argument.
Well, I think that in 215202, the knowingly modifies every single element of the statute. And I think that I believe that's in subsection F or subsection I. But the fact of the matter is that if there is that knowing requirement that's going to apply to every aspect of their conduct, and when they encounter someone who says, gee, are you an election official? And they tell them, no, we're not. What they know is that voter is no longer confused. And so I don't understand how the knowing element, if they actually apply that to, if that provision is applied to every single element of the statute, including the reasonable component, which is in there in 215202F, I think that makes it a strong case for the statute being focused on their own mental state, their own scienter, which is a knowing standard, and that under the counterman reasoning is adequate.
I understand that for A1 and they are representing themselves as an official, but I'm not sure I fully follow your argument about engaging in conduct that gives the appearance of being an election official. My understanding from what you said is that they clarify that, but what happens to the unreasonable person who is also a silent person and doesn't give any indication that they think they're an election official?
Thank you. Yes, and I think that then we retreat to cases like Alanis and Ruan, where we say that there needs to be that criminal culpability. And so if they didn't have that element of criminal culpability when they're engaging in that particular conduct, then there's no way that they could be convicted.
The problem is Justice Stegall has got, I think we're back in that circle of they have engaged in the knowing culpability because they know people can be confused. And it doesn't say that they are, that it just says that they can, that it gives the appearance.
Well, and I will acknowledge that this legislation did not represent the high watermark of legislative draftsmanship. But I think that when you apply the statute in a manner that is designed to allow it to pass constitutional muster, which under the case law, I believe that's what the court must do, I think that it can be read in a way that would then ensure that the individual has that sufficient criminal culpability in every aspect of its conduct. And so,
We need to read in to the statute to make it constitutional in your view.
well, I think that what your first is ensuring, and this is, and I don't know if you want to call it reasonable, reading into it or simply construing it in a way, but regardless sort of semantics. But first, I think that there is a reasonable person standard and in the individual who is the listener, but also I
I'm
think
sorry,
that,
counsel, is that a jury question?
no, I think that would be a legal question, Your Honor. I think that that's a
So you'd have to-
statutory
just so- but
construction.
You'd have to be arrested, booked, bond, the whole bit, and then eventually file a motion to dismiss as a legal question as to whether the conduct that you did out there in the parking lot of the Walmart, whether that was, whether you would know that conduct portrayed you as an election official to a reasonable person. That sounds, I mean, I don't know, that sounds to me like a jury question, but even if it's a legal question for the judge, that has a tremendous chilling effect on this speech, right?
Well, I think that if
A
this,
lot of trouble to go to find out whether what you did was correct.
I think if this court were in its opinion to apply that construction and provide an interpretation that then would guide the public's conduct, that those kind of issues could be avoided. So, I mean, I acknowledge that if you read it in the way that they want to read it, in the most uncharitable way, then those issues can come about. My point is that this statute can be construed consistent with traditional canons of construction in a way that I've articulated, and I think that would avoid these harms.
What's the state's? So this statute criminalizes the dissemination of truthful information, correct?
No, I think
It
that,
has to. I mean, if this person who's looks like an election official is handing, and let's say they're just handing out pamphlets from the election office, perfectly accurate information, they can go to jail.
I do not think that simply handing out election materials is the kind of conduct that is intended to be addressed by the statute. I
How
think
do
that
we find that language in the statute that doesn't make any sense really to me.
I think that the way the statute can be construed is to knowingly engage in that conduct that causes a person to think that you're an election official. And by that, it would be encompassing conduct like using telling individuals that you are, that you are an election official. That can be part of the A1, but more subtle conduct like using official forms, like taking county letterhead, for example, and writing on it without authority, without permission, and disseminating that to the voters that then cause them to be influenced by that decision. If it's simply handing out literature, I don't think that there's a reasonable argument for construing that as knowingly engaging in conduct that to make people think you're an election official. I mean, I understand that that's what they're arguing. I just don't think that is.
But still, the
that's
answer to the
interpretation.
question is it doesn't matter to the state whether the information being disseminated is accurate or not.
I don't.
It's how the person distributing it acts.
Well,
Right?
so I do think, I do think the latter part is true. I think that is the focus, but I do think that the accuracy of the information can be problematic if there's an attempt to unduly influence a voter. Let me, if I can provide an example. I mean, what if you have, for example, someone who takes a county letterhead and sends that out to voters and says, you must, in this election, you must vote by mail. Okay, that this is now required. I mean, that's not
That's wrong,
required.
but that's not accurate information, so your hypothetical doesn't fit my question.
Well, I think if there is, if what they're providing, if they're still, I mean, there is, US Supreme Court has frequently recognized the importance of, for example, prohibitions on impersonating election officials, because it goes
We're
to,
not talking about that because that's covered already by
well, what if
Section
it's
1.
more subtle conduct though, Justice Biles? I mean, if it's the kind of thing where,
But again, if it's subtle conduct, that's over here. I'm focused on the information that's being disseminated
yeah,
by this person. And if that's 100% accurate, you can still be prosecuted, right?
I think that if there is, I think that to the extent that it is entirely truthful information, then I don't think that that person would be knowingly engaging in as an election official. That's how we would construe the statute, and I would hope that that's how the court would construe that as well. I mean, if you're simply disseminating truthful information, I mean, in their role, handing out literature, for example, I don't think that that violates the statute.
Then all you'd have to do is amend the statute to say disseminating false voter information. And you've got a much better case, but this statute doesn't care whether the information is false or not.
Yeah, I think that what the legislature had in mind, and may not have drafted it in the best possible manner, but I think what they were trying to deal with is the amount of confusion that occurred during the 2020 election, when, as a good example, voters were told that they were sending out, organizations, for example, were sending out literature, and they were going then door to door. And here's another example. I mean, they were going door to door asking voters for specific information. And often, and it was accurate information, right? I mean, it was, hey, we want your voter data because we want to encourage you to vote. It turns out a lot of those were nefarious actors. They were trying to use it for nefarious purposes. It was accurate information, and they were going and they were essentially knowingly engaging in conduct where they knew that the person at the door was going to think that they were an election official, and then they ended up using that information for identity theft or other.
You can criminalize the use of information without criminalizing the door-to-door expression that happens.
Well, I think they were trying to get at the most effective way to block that, is what they felt, and they felt that when you come in with the imprimatur of a government official, then that tends to influence the behavior of the election official, of the voters, and I think that was where
I know, but in this First Amendment, I mean, you can kill an ant with an atom bomb, and that's pretty effective, but it does a lot more.
right. I
Before I
understand.
get into and I'm trying to focus on the narrowly tailored aspect, but okay, I've taken up too much.
Counselor,
I-
it
yes,
seems
go
to
ahead.
me that the information that this statute is arguably concerned with is not the information being disseminated. It is the perhaps nonverbal information of the status of the speaker. In other words, is the speaker an official representative of a government?
Right, and
Is that correct?
that is correct.
So it
and-
doesn't matter whether whatever information is, that statute's not aimed at regulating the truth or falsity of the information being disseminated. It's aimed at regulating the truth or falsity of the specific information of the status of the speaker.
That's exactly right. And it's just like a normal impersonation statute, which the US Supreme Court has said, the reason why those things are permissible is it is designed to protect the reputation and integrity of traditional
Well,
government processes.
And I think you would probably agree I mean, the whole reason we're here is that this is not a normal impersonation statute.
Yes,
It
that's
doesn't
right. I mean, we're
track
dealing with more subtle conduct. And I would also point out, I mean, just in Counterman itself, I mean, that case was focused on the views of of the listener as well. And the Supreme Court added in a criminal culpability element and said, that recklessness there was enough, but they did allow that statute to pass muster.
Oh,
No,
just
yeah.
one final quick question. We got a 609 notice from one or maybe both of the parties about pending legislation that at least proposes to modify the language of this statute. I know we have no idea whether that eventually becomes law or not, but since this is probably our only opportunity to ask you the question, if some amendment to this statute were to become law during this session, would that moot all the issues that are now in front of us?
I think in this particular appeal, yes. I mean, I would note to the court that bill is above the line today in the House and it's expected to pass the House today.
So your
And-
position is if that passes in whatever form, it moots the issues that we're talking about?
Yes, I do think so. And I think that
Can
is
you explain-
likely to be, I'm sorry, I didn't mean to interrupt.
No, I didn't mean to interrupt you. I'm sorry.
I just was going to say that my understanding, and obviously I'm not a legislator, is that it is scheduled to be considered in relatively prompt order. And obviously the legislature will work its will and who knows, how the end process, but I mean, I would, or might consider that there could be a mooting legislation in relatively short order.
Can you explain to me on this legislation the difference between section 1, which is the representing oneself as an election official, and the new section 2, which is engaging in conduct with the intent to cause a person to believe that the person engaging in such conduct is an election official? It seems to me that new section 2 swallows section 1 unless we apply
Well, I think.
statutory construction in some way and said it must be trying to get to something else.
I think it is designed to deal with more subtle conduct. And in fact, the testimony at the hearing last week was that the kind of situation that I just gave, where you have individuals who go door to door, just as one example, who are, they're sort of not going and they're not being explicit. They're trying to engage in much more subtle conduct, or they're, distributing literature where it's not, are they really impersonating an election official, or are they just, sort of, it's a more subtle type of conduct that could reach broader limits.
But that conduct that you've just described would be included in a in any kind of representation of an elected official. It's still conduct. I can't separate out one from new section 2. And if I can't do that, then I've got to wonder what's at play.
Well, I think maybe not. I don't know that I'm prepared to concede that point that one would swallow 2. I think that there could be conduct that on a more subtle basis where 2 would apply and not 1.
I understand that.
Yeah.
But every 2, but a 2 can be a 1.
I don't
one
know.
Can always be a 1 will always be a 2.
I would say that it is, no, I mean, no, I think there could be situations where you're not specifically trying to represent yourself as an election official, but you're engaging in conduct that you sort of know is going to cause that person to believe. I mean, it's a subtle difference, but I think that's, I mean, and I would also point out, I mean, that the fact that there may be some repetitiveness to it, and I don't think there is. I mean, that's certainly not infirm for the constitutional purposes.
Before you sit down,
Yes.
One of the discussions we had with your counsel was the vagueness, the second prong of vagueness, and whether the statute guards against arbitrary and discriminatory enforcement. And nobody briefed in this case is an example of that. We have the Douglas County District Attorney, the top law enforcement officer of Douglas County, a populous county in the state, that says she will not prosecute based upon this crime. And I think she calls it too vague and too prong and threatens too broad and threatens to make felons out of dedicated defenders of democracy. Kind of a position of that. And doesn't that invite, if you're a resident of Douglas County, the chief law enforcement officer of Douglas County isn't going to prosecute based upon this statute. If you live somewhere else, perhaps you are subject to it. Why doesn't that fit that prong of vagueness?
Well, I'm not going to criticize the Douglas County attorney.
And
or her
I'm not
motive.
inviting
Yeah,
that, but
right.
it's just the point.
Yeah. I think, I mean, first of all, as a factual matter below, the Attorney General, former Attorney General Schmidt had issued a press release saying, look, that all statutes are enforced in the state, and if some law enforcement official has a violation of any election statute, and he wasn't even simply referring to this one, and a local district attorney will not prosecute it, then my office will prosecute it. So I think that whatever her motives on that matter, I mean, I don't think that there is anything that would suggest that in Douglas County, those cases, those crimes would go unprosecuted as a general matter. And can I just answer one question that you asked, opposing counsel? I realize I'm out of
Yeah.
time.
It depends which one. No.
Well,
No,
you had asked, what should we do if the court
Yes,
ends
and
up?
that was going to be, I had that question for you too.
Okay, great.
Yeah, tell
Thank
me,
you.
yes. What should
So I mean, I would just first point out that there is no record. I mean, we have some affidavits in this case. And again, I mean, I know that Justice Biles and I had sort of had a dialogue about what we think that the court should do in terms of the statutory construction. But I would also just point out, and you can take judicial notice, if you go to the hearing that was held last week in the House Elections Committee, they've made sort of the sky is falling and hey, we haven't been able to conduct any voter registration activities for years. But the representative from the League of Women Voters made clear that they are conducting voter registration activities. We also pointed that out in an exhibit to our supplemental brief, but she says, oh yes, we're still registering voters. We have tables. The only thing that we're doing is that we are, instead of providing the voter with the actual form, we're giving them a QR code. So this notion that oh my goodness, we've had for 21 months now and we haven't been able to do anything. And I would say that that's simply not accurate. And
But
I
wait a
think
minute,
that-
wait a
go ahead,
minute.
please.
Doesn't that just show a willingness to accept the risk?
Well, I think that they have said that they have, I mean, they claim though in the factual record that they have cut off all voter registration activities because of this. And that's why they said that there was the imminent harm. So, I mean, my point is simply that it is entirely inconsistent with the representations they made in their affidavits and below. So sure, I mean, you could make that argument. I'm simply pointing out as a factual matter when they've said that I mean, they have said all along that they have not been doing this. And then at the hearing, they indicated that they had. That was my only point. Okay, if there's no.
I have one
Oh, yeah, please.
final question on, as I understood your argument, the distinction between A1 versus what is the conduct or communication that's targeted in A2 and A3 is the more subtleties and that maybe implies that you are affiliated with an election official. If that's the case, I would anticipate the opponents would suggest that feeds into their vagueness argument, because what does that mean? So I would just like to hear how you would respond to that.
Well, I would say that the focus is in our interpretation is focused on the speaker and so and their criminal culpability. And so if there was no criminal culpability on their part, then the fact that someone might have been confused is ultimately irrelevant because those individuals cannot be convicted.
The mens rea and then
Yes.
the reasonable listener
Right.
would cure that.
That's correct. Thank you.
Thank you.
The speculation about what the legislature was trying to get to with these laws is completely spun from whole cloth. These laws were barely discussed. It was a gut and go. The language was put into the bill in the Senate, and the only discussion was in the conference committee. In that discussion, legislatures identified some of these problems, saying, oh no, this looks like language that could catch up. Activities by the League of Women Voters. We really should do something to change this language. And the conference committee refused to do it. So the idea that this court can now rewrite this legislation to do what the conference committee refused to do is obviously beyond what courts usually do. There's evidence in the record of that at R1-186 and 87, R1-196 and 97. As Justice Biles pointed out, if you're concerned about false representation, misrepresentation, giving false information to voters, you can put that in the law. In fact, Kansas statute 25-2415 makes it a felony to give false information to voters to intentionally impede their voting rights. That's not what this law says. I also want to draw your attention to 25-2420, which is the law that makes election fraud by an elections official. And it has a very specific intent, an intent to hinder, prevent, or defeat a fair election. Notably, that's a level 10 non-person felony, significantly less prison time than this law, where it's still unclear what it does. The new legislation that has been proposed, it's obviously not law. We don't know if it'll ever become law. We don't know what it will say if it does. But I think that you hit the nail on the head. It's not clear what the new A2 does that A1 doesn't do. And
Could you really quickly just, I would like to get the plaintiff's perspective on my mootness question.
yes, it won't be moot, Your Honor. If let's assume that the language before the legislature now is the language that becomes law, because like obviously.
So then why wouldn't it be moot, I guess?
Well, for a couple reasons. So number one, as this court has held in the Gannon discussions, when there's still an issue of unconstitutionality, you can still reach it. And the Supreme Court, and I apologize.
If what you're saying is that the new language might also be constitutionally infirm, and that issue might be properly observed in this lawsuit, that makes complete sense to me. But I guess my question is, if the language we're arguing about is struck from the books, like what's left for us to do?
So if the proposed legislation now were to be amended and were to strike A2 and A3, which is what we're asking for, the law would be moot.
You would get what you
Right.
want, and that
Right.
portion of your argument is at least moot.
But right, but the proposed legislation doesn't strike A2 and A3. It strikes A2 and it modifies A3.
Okay.
And so it leaves this other sort of perplexing, what does this mean, engaging in conduct with the intent to cause a person to believe that the person's engaging in such conduct, that what is that that's different than A1? There's still a vagueness problem there. And I just want to say, it is, obviously this is all outside the record, and right? But if you go back and look at the legislative discussions in the House Elections Committee, it is very telling. At the first meeting, several of the plaintiffs' representatives testified. I totally disagree with the categorization of the testimony, but we won't get into that. But one of the, they talked about how we still don't know what this A2 is that's different than A1. And some of the legislators seemed very receptive to that. And they said, you know what, let's think about how to be more specific about what it is that we are after here. And we'll go back and we'll see if we can come back with that language. When they came back Friday, they said, we tried. We couldn't do it. We gave up. We decided that the intentional mens rea will save someone from being wrongfully convicted. But of course, that doesn't save someone from the fear and the chill, which itself is a constitutional infirmity. Thank you very much.
Thank you to both counsel for your arguments in this case. The court will take this matter under advisement.